Red light flash. Yep.
Okay, so we are group 2. My name is Angela. That's Christy, Amy, Lindsay, Danielle, and Don. And together we did government laws and recruiting, selection, and hiring. So like I said, my name is Angela. I'm covering the BFOQs, which stand for Bona Fide Occupational Qualifications, and the ADEA, which stands for Age Discrimination in Employment Act. For both of these, I will be covering the history, cases, do's and don'ts, examples, and more. So BFOQ stands for Bona Fide Occupational Qualification. They are employment qualifications employers are allowed to consider while making hiring decisions, but only if those qualifications are essential to the job requirements, and that's important for this definition. There are 3 general grounds for establishing BFOQs. One being authenticity, which refers to the genuineness of the requirement. An example of this would be a director casting for a movie and needing a male to fill the male role, or the fashion industry in general, where they specifically need male or female models. My second one is public safety, which refers to hiring employees with protected class characteristics in order to protect others. An example of this would be hiring males for certain prison positions that may be deemed too dangerous for others to handle. And lastly, the last general ground for establishing BFOQs is privacy. This involves requirements for employees of a particular gender. An example of this would be hiring women to work the dressing rooms in Victoria's Secret, or hiring female caregivers to assist with female clients. Some examples of unacceptable BFOQs would be refusing to hire a janitor in a church because he or she is not that religion, or height requirements for police officers. Both of these are unacceptable because height and religion are not essential qualifications to perform either of those jobs. So for my first case I have was a 1997 class action lawsuit was filed from a group of men who were turned down for the server positions at Hooters. Hooters, as a result, opened up a gender-neutral position, but claimed that the males could not work as servers because the Hooters girl is essential to their business and their brand. My next case is on Southwest Airlines, where they had a policy of hiring women flight attendants and ticket agents, and also capping the flight attendant's height at 5'9". All these discriminate against men. As a result, they lost because height and gender are not essential qualifications to perform either of those jobs. So for my next topic, I will be going on to the ADEA, which again stands for Age Discrimination in Employment Act. Kind of a loose definition of it is treating someone, either an applicant or an employee, less favorably due to his or her age. The EEOC defines the ADEA by forbidding age discrimination for anybody who is the age 40 or older. This does not include workers who are under the age of 40, but there are some states with laws in place that do protect these kinds of workers from this type of discrimination. So now for the history and the purpose. The ADEA was passed by Congress in 1967. It pointed out the disadvantage older workers had in retaining and regaining employment. Its purpose is to promote employment for an older worker based on their ability rather than their age. So age in BFOQ is newly added under the public safety section that I discussed earlier. An example of this would be the Federal Aviation Administration has a rule where airline pilots cannot serve as captains once they reach the age of 60 due to deteriorating skills. There's also a 2-step age test for analyzing age BFOQs, where one must show that either 1, there's a basis for believing that all or nearly all employees lack qualifications once they reach a certain age, or that 2, age classification is necessary to perform the job. And of course there are enforcements. where employers are required to post notices providing information on the ADA in a spot where employees can read them very easily. Also, employers are required to make and maintain records for all their employees and maintain them for 3 years. And if an employer violates the ADA, the person suing may recover from lost wages. Also, the court may decide to make the employer either hire or promote the individual that was denied advancement because of his or her age. My next case is on Marymount Manhattan College, where a 64-year-old woman was denied employment as an assistant professor due to her age. They gave the position to a 37-year-old because they claimed that she was at the right time in her life to commit to a full-time position, even though the 64-year-old was a leading candidate. My next case is on Texas Roadhouse, where a group of older applicants filed a class action lawsuit for being turned down for the front of the house server positions. And they claimed that the hiring officials said things like, "You seem too old to be applying for this position. Do you think you would fit in?" So in summary, BFOQs are only valid if they are essential to the job qualifications. Also, it's important to keep in mind for the ADA to hire people based on their ability and not their age. So to kind of relate this back to me, I currently intern at the Franklin Institute, and I kind of wanted to see on my own if I could find these postings that the ADA makes employers have, and it was to no surprise that I found tons of them posted everywhere where employees could see them visibly. My next slide, I have a picture of it. That's only a little part of the ginormous poster that I found from Pennsylvania, where it says things like you can't discriminate against everything under the EEOC, including age. And they also have their own policy, which they post online, which says pretty much the same exact thing. Okay, so Christy will be handling the ADA.
Okay, I'm Christy. I'm doing the American Disabilities Act. I'm going to go through a brief history and review of what the American Disabilities Act is, as well as a couple cases that have unfortunately come across the ADA. So the ADA is a Civil Rights Act that prohibits any employer to discriminate against somebody due to a disability or a long-lasting case such as cancer and remission. Alright, the ADA, although it was originally signed and passed in 1990, it was first brought about to Congress in 1988, and then it was originally thought of along with Section 504 of the Rehabilitation Act in 1973. So under the ADA, you are covered if you have any type of a mental or physical impairment that substantially limits one or more major life abilities. Discrimination is based on treating a qualified person unfavorably, even if they are qualified for the job. The law requires employers to come up with some type of a reasonable accommodation, such as somebody with a wheelchair have access to their job or to the building of any sort. It is defined by the EEOC as a change in a work environment, and the law also demands that employers cannot ask you about any disability or medical history. Disability defined by the law is any physical or mental history. Basically things like mental impairments such as autism, physical such as a missing limb or blindness, hearing impairments, speaking impairments. According to SHRM and their website, not all disabilities do require a wheelchair or crutches. Some of the examples covered would be diabetes, cancer, again, autism, post-traumatic stress disorder, different types of depression, OCD. Impairments resulting from pregnancy can also be considered a disability due to C-section complications or complications with having a needle or just something going wrong during the pregnancy itself. So the Office of Disability Employment provides programs to help employers find qualified applicants who do have disabilities or are in need of work. The EEOC does not require organizations to hire unqualified applicants, though. It does state that people must be qualified and have a disability that is stated as a disability by the law. So it does place limits on asking people through the employers during interviewing to take a medical exam. And it also puts a notice for each state and employer to have a listing that due to disabilities that somebody must help the customer or a client, an employee, if they need it due to a disability, whether it's their service animal or not. So I'm going to go over Nemours as one of my cases. A lab clerk was fired due to numerous health conditions of hers. The company stated that she was a safety hazard to herself and other employees in case of an emergency. An ADA expert came in and tested and found that she did not pose any threat to herself or others. The company managers then admitted to never looking into any possible accommodations. She was ended up awarded $91,000 in back pay and $200,000 in forward pay. Sears was also a case done in 2009. They maintained an inflexible compensation leave exhaustion pay and terminated rather than accommodating any disabilities. They ended up finding 235 eligible employees throughout the entire company. The approximate amount they awarded everybody was $6.2 million a person. My next case I'm going to talk about is Starbucks. They were in 2007. I actually learned this in another class. There was a barista there who had mental impairments. Her original manager gave her extra training. He would help her throughout the day. She performed spectacularly. A new manager came into the business with her, ended up taking away all help that she had. She ended up being berated in front of customers and ended up losing her job in the end. Starbucks ended up settling for her $75,000 to herself and then an additional $10,000 to the legal Disability Legal Rights Center. My last case is the United Airlines in 2009. There was an employee who worked for the airlines themselves on the ground. He was under different medical restrictions pertaining to working with machinery and heights. Normally he would receive overtime beforehand, but after a point he ended up receiving none whatsoever. Okay, so basically with the ADA, if you have any kind of a disability, yes, you do need a doctor's note, which most cases you have one automatically, but also every job has to have some kind of a reasonable accommodation. So my new and you, not many people know what it is. It's an insulin pump, an insulin vial, and syringes. I work for Wawa. I myself, when I went on maternity leave, became dependent on an insulin pump. Here, when I came back to work after leave, I had found out that my sites would come out, I had to refill everything, my bosses were not giving me breaks to take time and refill my medications. My area manager had this brought attention to her, ended up filing with me a claim. So Amy's going to come up and talk about pregnancy, religion, and national origin.
Is that on pause?
Yes.
Finish your story.
Alright, so my area manager, it was brought to her attention by my assistant manager, who also is on an insulin pump himself. My general manager
But he
and
didn't have